post saying that I was going to be here conducting this live stream at 8:30. Unfortunately, I got caught up doing something else because another matter that came across my path needed to be attended to. But I'm here now. And as I said in the prompts, we're going to talk about the Second Amendment to the Bill of Rights today because I believe that is a topic of discussion that many of us Americans need to speak about in order to obtain certain information that many of us have not been privy to throughout the years. Primarily because those in civil service have manipulated our minds into believing things about the Second Amendment that is just totally not the case. So that's why I come in at. For those of you who are unfamiliar with who I am, my name is Okang Rochelle. I've studied law for over 20 years of my life on account of a situation that I was involved in, which prompted me to study law to ensure that I myself, to include other people, were not taken advantage of by those in civil service uh, employed within the executive and judicial branches of our national government or a centralized government of a specific state. With that being said, many people in America tend to believe that the invocation of the Second Amendment to the Bill of Rights, which permits everyone here in America, especially us civilians, to keep and bear arms. And what the terms keep and bear respectively means is that we have not only the right to openly carry whatever firearm we choose to have through exercising our right to liberty, but also to conceal those particular firearms or other weapons in which we choose to have, in which we feel is best suited for our personal defense. The reason why there's so much talk about the Second Amendment in this country is based upon what I said earlier. Members of Congress, the state legislators, governors, presidents, judges, attorney generals, prosecuting attorneys, having manipulated that particular freedom in order to fulfill their own personal business, financial, political, uh, and oftentimes spiritual interests or agendas. They take the encroachment upon our civil rights, specifically the civil right to keep and bear arms, being that that is the only right that we have that is necessary to defend every other freedom. But they do not want us to exercise that freedom to the extent that the Second Amendment was ratified in respects to that. And knowing that, one of the things that I had to ask myself was why? Because when you study law, you tend to see things that members of the general public rarely see. In addition to that, for those of us in the general public that actually see specific things that we do not agree with, in which we know to be in breach of the Constitution, Declaration of Independence, Bill of Rights, to include the Universal Declaration of Human Rights, it tends to shed more light on the situation once we start uh, uh, getting involved in studying law and politics, of course, because we all know, for those of us who do, that there cannot be any law without politics, and there can be no politics without law. They both go hand in hand. For politicians, create law. Without politicians, there will be no law. Understood. One of the things that the Tribunal of the Supreme Court for the United States of America has said on various occasions in the past through the invocation of judicial precedent is that the law says what it says and, of course, means what it says. Many people have not grasped that realization because many of us civilians, for the most part, do not know about what the judges in the Supreme Court have said about the invocation of specific freedoms that are supposed to be protected and respected by those in civil service. I filed various legal petitions in the past, not only in my behalf, but on behalf of other individuals as well. And I have been successful in ensuring that many people got the relief that they were entitled to under law. Uh, Most notably, when it comes to the respecting of civil rights, I happen to help one of my homeboys out who goes by the name of Charles Lester Van Ness, aka Midnight, brother from the District of Columbia. He was in a federal prison institution for over 20 years of his life for an offense that he was not even convicted of. That may seem strange to a lot of people, but that is the absolute truth. So when I end up taking this individual's case, I end up finding out things immediately upon reading the transcript, since that is the document that they base whatever facts that transpired in a specific judicial proceeding off of. I noticed that the judge made a few mistakes, most notably when the judge informed the jurors that they didn't have to find Mr. Van Ness guilty of the offense that he was charged for with regards to possessing 50 grams of crack cocaine. That was a mistake. So when I brought that mistake to Van Ness's attention, he ended up following my legal advice and writing the judge, Judge Lambert, out of the District of Columbia to be specific. Judge Lambert, for whatever reason, and I have to believe that that reason was based upon the correspondence in which Mr. Van Ness submitted to him, taking my advice and preparing it, reopened that brother's case by informing members of the Federal Public Defender's Office to look into the case to uh, get a better understanding on what transpired and what should not have transpired. I used to role play with Van Ness all the time because one of my things is when we're talking about law and politics is that one has to be in a position to speak in his or her behalf if an attorney drops the ball in doing so. And believe me, that happens far too often in the so called criminal justice system. It's just that that is not known to the extent that it should be known, as far as I'm concerned, and of course, many others for that matter. Van Ness ended up getting out of prison, y'all, within 1 year after I took that brother's case. But I also have to commend him because, unlike other individuals whom I have attempted to help, they never, for the most part, took their situation as seriously as Mr. Van Ness had. One of the things that we have to understand when it comes to litigation is that you have an attorney and a defendant. The defendant knows more about the facts of his or her case because they were actually there at the time whatever happened transpired. The attorney is supposed to know more about the law as that law relates to the facts of a defendant's case. So when you put those two together, that is what formulates a solidified legal defense. It goes both ways. That is why Van Ness was able to get out in such a short period of time after all that brother went through. He played a significant part in his own legal defense. He never gave up. He ended up just taking my advice on the whim. And I remember him telling me that based upon everything that I've showed him, which came into fruition, that he didn't have to question me anymore. Whatever doubts he may have had about my experience and knowledge to actually litigate in the court of law, he no longer, according to what he told me, uh, felt the need to question me. He had no doubts after speaking to me and actually going through the process and seeing results. Getting back to what I was saying, the jurors didn't find Mr. Van Ness guilty of what he was indicted for. And one of the judicial decisions that was rendered by the Tribunal of the Supreme Court for the United States of America signified that if a jury didn't find an individual guilty who actually exercised the freedom to a jury trial, whatever the juror said in determining the matter of that case is what stands. The jury's decision trumps the judgment and commitment issued by a judge. Mr. Van Ness was not found guilty of possessing crack cocaine, y'all. He was not found guilty of possessing a specific amount that he was charged for in the grand jury indictment. Therefore, that is what prompted members of the United States Attorney's Office to concede with the argument in which I brought to Mr. Van Ness's attention, in which he conveyed to members of the Federal Public Defender's Office who ran with that particular argument. And they conceded that the brother should be discharged. And that is exactly what happened. But I bring that point up because I've never been to law school. However, I have utilized the same resources in which lawyers utilize when going through law school to obtain the requisite knowledge of law in which I possess today. In fact, there's been many occasions when I have litigated in the court of law, and various federal court judges and state court judges have asked me, why haven't I taken the bar exam and become an attorney at law? My response to that question has always been and currently remains that I will never become a part of the current American Bar Association because that particular organization is comprised of individuals who do not have the civilians of this country's best interests at heart. And I give y'all an example of what I found out through studying law, being on the inside, things that they don't want us on the outside to know about. Did you all know that if an attorney represents you, it doesn't matter if this individual was court appointed or retained, they are bound by the same rules established in the American Bar Association or some state bar association. They have a rule that an attorney cannot say certain things if it's going to tarnish the reputation of another colleague or an individual within that particular field. In keeping that in mind, that's like if I'm an attorney and I'm represent, let's say, Tupac Shakur, and there was something that the police officers did in Tupac Shakur's case in which they should not have done, in which if it was revealed what they have done, they can actually, let's say, be penalized legally or um, stripped of whatever position that they have within a local law enforcement agency. The rule that I'm talking about, in which I have came across, was that I could not say anything about a police officer that was going to tarnish his or her reputation. So, with that being said, that means that I am going to throw my client under the bus in order to save someone else's face who actually broke the law, who actually went against the rules. That is why so many attorneys seek to have clients accept or take guilty pleas. I've seen many times in the county jail, attorneys never even met with a client. They go into that meeting room, and the first thing these attorneys ask these clients of theirs is, do you want to take a guilty plea? Didn't investigate the case, didn't do none of that because attorneys know that once a defendant or client accepts a guilty plea, they are admitting guilt. So no matter what transpired, whether it was right or a lie, the defendant has to live by what it is that he or she accepted in agreement on. I don't agree with that. I don't agree with manipulating people by preying on people's ignorance or fear to get them to do something that they typically would not do under a specific situation. Another thing that I learned, we have a Sixth Amendment right to a fair trial by a jury of our peers in this country, right? An impartial jury or jury. However, for those who choose to invoke the Sixth Amendment liberty to a fair trial by a jury of their peers, they are constantly threatened by judges, attorneys, and prosecuting attorneys with getting more time if they choose to go to trial and they are found guilty of that offense after invoking his or her right to a fair and public trial. That is something that I too do not agree with. Because if an individual is going to plead guilty and accept guilt, what makes them um, any more special to get a reduced term of imprisonment as opposed to someone who exercised his or her right to a fair trial and was found guilty by a jury of his or her so-called peers? This is the reason why I tell you all that knowing the law is very important to us civilians. Because if we do not know the law, if we know nothing about politics, we will never be in a position to counter those in civil service when they put certain obstacles in our path to keep us oppressed, to keep us bound, to keep us docile. And that is where the Second Amendment to the Bill of Rights come into play. The Second Amendment to the Bill of Rights specifically says that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. That's what that amendment says in its entirety. Easy to understand. The words are well written to where there can be no deviation from the point in which the founding fathers made at the time that they created or ratified this particular freedom under the Bill of Rights. We all know that when it's talking about the right to keep and bear, those two words respectively means to either openly carry or conceal carry. So we already have a right to openly carry our firearms. We already have a right to conceal whatever firearms we choose to own. We do not need anyone's permission in civil service whom we place there to exercise that particular freedom. We don't need any licenses issued by them in which we and them have to pay for, come out of our own pockets. Everything that those in civil service do associated with the American government has already been prepaid through our tax dollars. The courthouse that was built was funded by tax dollars. The judge's salary that is being paid, funded by tax dollars. The copy machine, paper and ink that those copper machines run off of was paid for by the American taxpayer. So who the heck are civil servants in public office to tell us, the electorate, that we need their permission to exercise certain rights because they do not agree with us exercising specific freedoms? And it doesn't make matters any better when civilians in this country allow those in civil service to do what they do on account of how they feel at a particular moment in time based upon what has transpired in their lives. Now, let's take the Columbine school shooting, for example. After that school shooting occurred, now you have all these civilians whose families were harmed on account of the perpetrators of that particular assault, screaming that we need more gun control. We need gun control, gun regulations, regulations this, regulations that. Failing to realize in their emotional state that gun control is not going to solve the problem here. When I was young, y'all, how old was I? I think I was 13 years old. I went to school every day, for the most part, with a 25 semi-automatic handgun and two 50-round boxes of ammunition in my possession. I had that weapon and that amount of ammunition not to harm one of my fellow students or teachers in that school. I had it just in case someone came into the school and did exactly what transpired at the Columbine high school. I remember my mother telling me at that time that I didn't need a gun, um, especially to take one to school because I was so young and nobody would harm the children. That's what my mother said. But I disagree with her, which is the reason why I went against what she said and did what it is that I did. Now, mind you, I never committed the crime with that particular firearm, but I had it for the purpose of self defense. And there was nothing wrong with me having a gun, in spite of what so many adults claim in this current day and age. They don't believe that young people should take guns and knives and stuff to school. But young people are carrying knives and guns to school in this current day and age on account of what has transpired in the past. That's something that we all, I'm already there, need to understand. There's nobody there to protect them. It doesn't matter if you have two armed security guards at a freaking high school, at a freaking college, because those two individuals cannot cover every inch of that particular learning institution. So someone is going to go down, but nobody wants to go down. So why should those in civil service be the only ones in this country, according to what they believe, in which they have manipulated many other civilians to believe, to have access to all types of armament to protect themselves, their family, and friends? While at the same time, they're telling us we don't have that specific freedom. You know, the president of the National Rifle Association many years ago made an excellent point. I don't know if any one of y'all remember this, but I'm going to assume that depending on how many people watch this live stream, that some of you are familiar with what I'm about to say. After those school shootings occurred, especially on more than one occasion, family members end up arming themselves to go to the schools to stand guard in an attempt or endeavor to protect their children and the children of other civilians. Members of the school, to include law enforcement personnel, claim to have had a problem with that. So the president of the National Rifle Association at that particular moment in time, he was saying that when then President Obama's daughters were in school, they had armed Secret Service agents with them wherever they went. They had Secret Service agents on the outside of the school, on the inside of the classroom, perhaps on the outside of the classroom, guarding this woman with who knows what type of arms that they were in possession of. So they're basically saying that Obama's daughters is more important than your daughter. And many of you accepted that nonsense because you believe that by virtue of Obama being the president, or any man being the president who has that particular title, has more sovereignty than you do. Many of you look at them as if they are godlike beings, kings that cannot be touched. And you all fail to realize that the only reason why Barack Obama and Donald Trump were able to obtain that position of public trust is because of you. So you all tell me, who has the real power in this country? Because as sure as heck wasn't Barack Obama, and as sure as heck isn't Donald Trump. There is no greater title here in America than the title of electorate. That is a title that you and I possess because we are voters. We are the taxpayers. We put them in civil service and we allow money to be deducted from our hard earned paychecks to fund their salary after they have taken a specific position of public trust. So don't believe that you all have no authority in this country. Do not continue to accept what they want you to accept as being the peons in this nation because you are not. None of us are. They are civil servants. They are not leaders. They're not officials. They're not people in power. We have the power because we cannot give someone something that we do not have in abundance ourselves. We elected Donald Trump and every other president that came before him. We put them there to represent our interests under the Constitution, to protect our rights, specifically the Second Amendment to the Bill of Rights from enemies both foreign and domestic. They have utterly failed in that endeavor. Now, I know Donald Trump's been saying, oh, he wants to make it to where citizens can have guns and all this and that. But one of the key words that he used is the term law abiding citizen. And that's a term that many people have grown prone to using. And I'm simply asking anyone who uses that term, what do you mean when you say that? Are you saying that because someone went to jail and they have been discharged, that they are no longer a law abiding citizen? Where are you all coming from when you say that? Because when you really look at things, if an individual did go to prison for doing what he or she was accused of doing, they've been discharged from prison, they paid their debt to society. They are now living a law abiding lifestyle by deviating from prior criminal behavior. When people do that, that makes them law abiding citizens. So we have to stop utilizing that term as if it differentiates people from one another because it doesn't. We all in the same boat. It's either we have the right to bear arms or none of us do. That is why those in civil service have utilized what many of you have allowed them to utilize to not only attack those with prior felony convictions, but also people without prior felony convictions. Look at what's going on in the state of Virginia right now. And how many of those so-called law-abiding citizens served on served as grand jurors or petty jurors during criminal trial proceedings and indicted someone for the offense of possession of a firearm by a felon? That convicted someone for the offense of possession of a firearm in commerce after felony conviction. I bet you many of those people did that. And those people did not realize that by opening up that door, that that right was going to eventually be open for infringement also. I know many brothers and sisters that's been incarcerated, whether they had been incarcerated for violent crimes or non-violent crimes, whether they were actually innocent or actually guilty. But when those brothers and sisters get out, they're not running around here committing crimes with guns, y'all, because they don't want to go back to freaking prison. And I'll give y'all a perfect example. My homeboy Charles Anderson from High Point, North Carolina. The brother spent time in prison on various occasions, and every time he went back after the first offense that was allegedly done when we were teenagers, he always had a gun on. And every time he got caught, some law enforcement officer through enforcing some erroneous statute that was in violation of the Second Amendment to the Bill of Rights, arrested that brother. And of course, some idiotic district attorney prosecuted the case, and some dumb judge uh, imprisoned the man. I remember after Charles got out, I think it was like the third time that he got out for having a gun. Now, keep in mind, I will reiterate, he didn't commit a crime with the gun. He was just possessing the firearm. for his own personal protection. And he came up to, well, no, he didn't come up to me. We actually met up at the courthouse, no less. And he said, Okang, I'm done. I'm not carrying guns no more because I'm tired of going back to prison. Do you all know that soon after that brother told me that, some idiots in the community that he lived in shot and killed that man because they knew he was unarmed. They knew that they had to shoot him because they could not beat him in a fair fist fight because Charles Anderson was like that. That man had combat skill, but he's dead now. Dead because of what? Because of some idiotic gun law here in the state of North Carolina known as the Felony Firearms Act. A law that violates the very Second Amendment to the Bill of Rights, which is supposed to reign supreme over every other law that has been in this country by members of Congress or some freaking state legislature. See, at that time, I didn't know as much about the law as I currently do now. I didn't know that in the well that in the case of McDonald versus City of Chicago, citation number 561 US 742, 177 LED 2D 894 130 SCT 320. A case that was written in the year of 2010 by the judges in the Supreme Court for the United States. I know on page 768 to that specific judicial decision that the judges of the Supreme Court, through interpreting the law, which is something that they cannot do, but for the sake of argument, we will accept that for this particular live stream. They said, and I quote, the right to keep and bear arms was considered no less fundamental by those who drafted and ratified the Bill of Rights, end quote. When the judges said that, when I came across this particular judicial decision through the course of studying law, I said, okay, that sounds good. They're saying that the Second Amendment liberty to keep and bear arms is a fundamental right. So now I'm looking up what judges have said about the deprivation of fundamental rights. Did they acknowledge that members of Congress, to include other state legislators, having the authority to impede upon fundamental rights, or did the judges say they did not have the rightful authority under the Constitution to impede upon fundamental rights? So as I started studying, I ended up coming across the case of West Virginia State Board of Education versus Barnett, another Supreme Court precedent. Citation number 319 US 624 87 LED 1628 63 SCT 1178. 1943 is when this case was actually handed down. On page 638 to that specific judicial precedent, the judges of the Supreme Court said, and I quote, the very purpose of the Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. One's right to life, liberty, and property, to free speech, a free press, freedom of worship and assembly, and other fundamental rights may not be submitted to vote. They depend on the outcome of no elections, end quote. Now I got to thinking, what actually transpires before a bill becomes law? In studying politics as well as law, I realized that some member of Congress or some state legislator or members, meaning more than one, they get together and they have a bright idea based upon whatever opinion that they have at that particular moment in time. They get together and they say, oh, you know what? I'm going to write a bill in which I am going to seek to have become law. Now, keep in mind, members of Congress, to include state legislators, they're always throwing it in our faces that they have been to law school, that they know the law, that they know the Constitution. So, in them saying that, I'm going to hold them to the same standard that they have indicated that they should be held under through the things that they have said to us about themselves. So I got thinking, okay, so they create a bill on paper or on the computer, however they want to do it, and they write out what the law is. 922G 1. It is against the law for someone with a prior felony conviction to have a gun. Okay, so they write that out. They know what the Second Amendment to the Bill of Rights says. They know that they were in breach of that particular amendment when they concocted that idiotic law or bill that eventually came or became law. So they had no regard for law, y'all. They're not law-abiding citizens. They are actually felons. Now, what they did through the course of creating gun control laws is that they deviated, they ignored the Second Amendment to the Bill of Rights, which specifically said that the right of the people to keep and bear arms shall not be infringed. When they restrict one's access to firearms, they are in essence infringing upon that freedom, which is something that the Second Amendment to the Bill of Rights has said shall not be done. So they're the true criminals. But here's the kicker. When they brought that bill to the congressional floor, within the legislative body of whatever political institution that they were associated with, whether that be with the United States Congress or, let's say, for instance, the North Carolina General Assembly here in the state that I reside in, North Carolina. They all ignore the Second Amendment to the Bill of Rights because they don't care about law. They claim that we don't care about law. Certain members of society who are considered criminals don't care about the law when it comes to firearms possession because they're going to get guns regardless, and it puts law-abiding citizens in a precarious situation to be hurt. The same scenario that they have applied to civilians should also be applied to them because they initiated this breach of law. They breached the law first. Just because they have a specific position of public trust does not permit them the right, the privilege to disregard the law when doing so benefits their personal, political, financial, business, or spiritual interests or agenda. So what they did when they had that bill on the floor, it was said, for example, Congresswoman Nancy Pelosi, do you agree with the Gun Control Act of 1968 being ratified? And she would respond, yay. And then they'll go down the line. Congressman Brad Miller, what do you say? Nay. That lets me know that Mr. Brad Miller didn't agree with the law. But that is how bills have become law, y'all. They had to vote on a bill in order to make it law. What does that particular opinion coming out of the Supreme Court for the United States of America say? And keep in mind that decision was written in the year of 1943. So members of Congress, before they enacted the Gun Control Act, they knew what the Supreme Court judges have said that the law was. And they still chose to ignore not only Supreme Court precedent in conformity with the Second Amendment, but also they ignored the Second Amendment to the Bill of Rights itself. So they're the true criminals, not us, not those of us who choose to exercise our Second Amendment liberty to keep and bear arms. No, it doesn't say the right of the people to keep and bear arms shall not be infringed unless one has been previously convicted of a violent or nonviolent felony. I mean, come on. It doesn't say that, y'all. We got to keep in mind that when the Second Amendment to the Bill of Rights was ratified, the founding fathers were doing things that people in this world considered to be criminal. They were considered to be fugitives from justice. by members of the British Empire. They were considered felons. But the moment they won the Revolutionary War of 1775 and established the Declaration of Independence, that is when people of the world started accepting them for who they wanted to be considered. But people accepted them because of what they were able to do, what they were able to achieve based upon, get this, exercising the Second Amendment liberty to keep and bear arms under the Bill of Rights. So when we all looking at guns as being there, as being some dangerous tool that just up and do whatever the heck it wants to do, whenever the heck it wants to do it, that is not accurate. That is not accurate. Fundamental rights are taken out of the equation when it comes to whether or not they are respected or disrespected by those in civil service, to include other civilians. That's what that decision in the Barnett case said. So if that particular amendment, the Second Amendment to the Bill of Rights, which is a fundamental or natural right, is outside of the purview of majorities and officials, because it depends on the outcome of no elections, and it may not be submitted to vote. That means that every act of gun control in America, whether that be on a national sense or a state sense, is unconstitutional. Just utilizing those two decisions in and of themselves. But we don't have content creators on YouTube. I have not yet seen one telling us about these particular cases. All I see is content creators attempting to get us to spend more money on these attorneys, which support them, in order for us to have these attorneys, technically, if you want to get technical, resubmit arguments to the freaking judges in which they have already been submitted in the past. And a lot of those arguments, the judges have ruled in favor of we the people. But you have some members in civil service who do not agree with that particular decision, so they still choose to do what it is they were doing before. So instead of, let's say, filing a complaint to have those dummies held in contempt and thrown in jail, these lawyers would rather take our money, submit another freaking case before the same freaking judiciary to get the same freaking ruling, only to be dismissed by the same people that the ruling was established to restrict. That's why I stopped giving money to these pro 2A groups. I stopped, y'all, because of that. Nothing's really getting done. Let's like the Bruin decision. Judge Clarence Thomas, and right for the majority, made that very simple. And it's really no other way to look at it. If a law did not exist in the year of December 15, 1791, when the Second Amendment to the Bill of Rights was ratified, that means that there's no history, text, or tradition related to these laws that they have established after the fact, which makes every law unconstitutional. That's just plain and freaking simple. But because people don't agree with that, they will come up with reasons as to why the judges are wrong. They want to put words into the decision in which the judges did not put there. But then again, judges do the same thing when it comes to the Second Amendment to the Bill of Rights, to include legislation enacted by members of Congress or some state legislators. So all them people are in the wrong to some extent or another. My gripe is, if they expect us to honor the law, when doggone it, I expect them to do the freaking same. And because they breached the law first, when they made these gun control laws that they know are in breach of the Second Amendment right to keep and bear arms, you have no legal obligation under the Constitution to adhere to any statutory provision ratified by some national or state legislature. We don't have to listen to them. We don't. And to prove that, direct your attention to the case of Robinson versus Baldwin. This is a Supreme Court decision, citation number 165 US 275, 41 LED 715, 17 SCT 326. 1897 is when this particular opinion was issued by the judges of the Supreme Court for the United States. On page 297 to that specific judicial decision, it was said, and I quote, "No court is bound to enforce, nor is anyone legally bound to obey an act of Congress inconsistent with the Constitution," end quote. Now, being that this is a case coming out of the Supreme Court for the United States of America, we can substitute Congress for any General Assembly that makes up this nation in every state. This is how, when you read judicial decisions, that's how it works. And of course, Robinson versus Baldwin, the judge in that case was actually citing Marbury versus Madison, which was a decision written by the majority of the judges in the Supreme Court. And the citation number for that case is 5 US 1 Cranch 137 2 LED 60. 1803 is when this case was issued. On page 180 to that specific judicial decision, the judges of the Supreme Court said, and I quote, "Thus, the particular phraseology of the Constitution of the United States confirms and strengthens the principle supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts, as well as other departments, are bound by that instrument," end quote. So if a law is repugnant to the Constitution, it is not the law that we adhere to. It is the Constitution that we adhere to, which means that we have to disregard whatever laws that have been ratified in contravention to the amendment to the Bill of Rights or any other amendment or article for that matter. But specifically, the Second Amendment to the Bill of Rights, because that is the primary right that those in civil service, to include other incompetent civilians, have grown prone in this day and age to violate. And that is why I say, when we disregard a law that is unconstitutional, a statutory provision, rule, regulation, ordinance, policy, executive order, judicial decision that's inconsistent with the Constitution, we cannot be held legally accountable for doing so. And that was made evident in the case of Ex parte Sibo, citation number 100, US 371, 25 LED 717. 1880 is when this decision was issued by the Supreme Court judges for the United States. On pages 376 through 77, to that specific judicial opinion, the judges of the Supreme Court for the United States said, and I quote, "An unconstitutional law is void and is as no law. An offense created by it is a conviction under it is not merely erroneous, but is illegal and void and cannot be a legal cause of imprisonment," end quote. Let's go back to my homeboy Charles Anderson, for instance, or for every individual here in the United States who has been charged with the offense of possession of a firearm by a felon. Keep in mind, they're talking about, in the aspect of felon, one who has been incarcerated or convicted on account of a prior felony or certain misdemeanor offense. They're not referring to an individual committing a crime in the present day with the gun that they were accused of possessing. They're talking about one's past. And we all know that if we penalize somebody on account of what they had already did time for in their past. We are subjecting them to acts of double jeopardy, which is in violation of the Fifth Amendment to the Bill of Rights. We all know that. In addition to that, when we subject people to acts of double jeopardy on account of what they did in the past, with regards to what we may think that they're going to do in the future, we are actually discriminating against them, which is a violation of Article 2 to the Universal Declaration of Human Rights, to include the Civil Rights Act. So everybody who does that, you all are in essence criminals. You're the felons of society, not an individual exercising his or her right that is protected by the supreme law of the land to keep and bear arms. It is you all who are the criminals who restrict one's access to keep and bear arms. You're the criminals. And because one cannot be penalized on account of disregarding an unconstitutional law, I ask myself, and I pose this question to each and every last one of you: why the heck did my homeboy Charles Anderson go back and forth to prison on 3 separate occasions for the offense of possession of a firearm by a felon, when we all know that that particular statutory provision is in breach of the Second Amendment to the Bill of Rights? When we know that that statutory provision had ignored Supreme Court precedent that was in conformity with the Second Amendment to the Bill of Rights. And still, Charles Anderson, amongst many other brothers and sisters. Right now, I got a homie named Charles Ford, Sean County, and Derek Dow, who has recently been sent to jail on account of exercising their right to keep and bear arms under the Second Amendment. They are not the criminals here. It is the police officers who put them in that position who are the freaking criminals. It is the legislators behind the police officers' actions who are the criminals, and it is the criminals associated with the constituency of this nation who have allowed our legislators to create firearms restrictions through the act of gun control. They are the actual criminals, the felons of society. And I don't know how many of you have been previously convicted of a felony or misdemeanor offense or not, but I can assure you that what I have spoken to you all about here today during the course of this live stream has not been raised by attorneys in this current day and age. And if it has, those particular cases have not been made public for population. Ask yourselves why that would be, and then you will have your answer. A lot of people claim that having an AR-15 is just so bad. It's just so negative for Americans to have it. No American citizen should have an AR-15. An AR-15 is not going to enable these citizens of this country to take on the American military. Oh, because they're so high and mighty. Man, I don't give a fuck about that nonsense. And many of you civilians say that, but many of you civilians who say that, you don't know nothing about the law as been conveyed by the Supreme Court judges for the United States, the very individuals with whom a lot of you look up to as being godlike beings and kings and queens of society, that knows all, that can do no wrong. Many of you believe that. And for those of you who believe that, in addition to believing that we don't have a right to take on the government through the act of revolution, let me read a case to you all. One of my favorite cases. It's known as Parker versus District of Columbia. Citation number 478 F3D 370 375 US App DC 140. DC Circuit Court of Appeals. Written in the year of 2007. On page 383 to that specific judicial decision, the judges of the United States Court of Appeals for the District of Columbia said, and I quote, the premise that private arm would be used for self-defense accord with Blackstone's observation, which had influenced thinking in the American colonies, that the people's right to arms was auxiliary to the natural right of self-preservation. The right of self-preservation, in turn, was understood as the right to defend oneself against attacks by lawless individuals, or, if absolutely necessary, to resist and throw off a tyrannical government. End quote. And of course, the judges of this particular circuit were citing collected cases in support of what they just said. So, in citing collected cases, that means that there's been many other judges who agree with this statement that was made in this particular judicial decision. So, for all of you who believe, erroneously so, that we, the people, do not have the right to bear certain arms in order to take on those who become tyrannical within the United States government, you are dead freaking wrong. And those within governmental positions who have created statutory provisions to outlaw our right to resist and throw off a government are dead wrong. Because those particular laws, as the laws are related to the Second Amendment, also are in violation of paragraph 2 to the Declaration of Independence, which gives each and every last one of us the legal authority to overthrow those within a governmental institution when those members become hell-bent on oppressing us through acts of tyranny, in which we have seen more prominently so in this current day and age. But because so many of you have been conditioned to be freaking cowards, you accept that nonsense. And you wonder why, during the course of accepting their propaganda, that you are being taken advantage of the most in this nation. Many of you want to physically defend those idiots in civil service. You don't know nothing about them. They don't know you personally. You don't really know them personally. But because by virtue of you liking them, for whatever reason that may be, many of you civilians have put your lives on the line for these people, and you fail to realize that they will not do the same for you. One of the things that I hate, I cannot stand when, let's say, a president such as Donald Trump, he wants to send men and women employed within the United States Armed Forces to fight wars that he started. My thing is this. My take of a true president is somebody like George Washington, somebody who was a general in the armed forces before he got that particular position. That is a man that's worthy of the position of commander in chief of the United States Armed Forces. Donald Trump didn't earn that title, y'all. Donald Trump don't go through training exercises with the soldier Secret Service. He's the president. He's supposed to be protecting people, not really the other way around. Now, see, if I was the president for the United States, if I went to war, I'm going to war with the soldiers. I'm the commander in chief under those circumstances, right? So I'm going to be on the front lines like George Washington was on the front lines. And in order to be on the front lines, me and these soldiers got to go hand in hand, which means that we have to go through the same training exercises to where we know each other's every move to enhance victory in a specific situation. There is no freaking way in the world, me being the man that I am, if I became president, that I would be sitting behind some door of an enclosed bunker while other members of society are going to fight a freaking war that I myself started because I was too much of a coward to fight that battle myself. So I heard a lot of you soldiers, for those of you whom this refers to, have decided to disregard whatever instruction Donald Trump has given you. That is your right to do that. You do not have to agree with an unconstitutional command or instruction given to you by the freaking president. Because believe it or not, you all have taken an oath to protect and defend the Constitution from enemies, both foreign and domestic. So if the president has become a domesticated enemy to the Constitution, you all do have that right without being court-martialed to do what you brothers and sisters, in which I have heard you're doing right now as I speak. And I commend y'all for that. And I'm with you. I know you all may not know me, and I don't know many of you. But if we're on the same page, that means we have a common enemy. That means that we are standing on the same principles. When we are doing that, when we have those same aspirations in mind, in my view, we are the same. You are my people. I may not never meet any of you in real life, but just know that wherever we fight, we stand together, right? What's the saying? Together we stand, divided we fall. That's what they say. I agree with that philosophy. But with that being said, I know this was not the live stream that I intended because, like I said earlier, well, soon after getting on, that something came up to where I had to handle. But I decided just to come on here to give you all a little bit of insight on what the law is and how laws related to infringing upon our Second Amendment liberty to keep and bear arms for the purpose of self-defense, um, laws that have been created to restrict our right to overthrow the government when those within governmental positions become tyrannical to the ends that they took an oath to uphold. We do not have to listen to those laws, y'all. As a matter of fact, in order to uphold the law, we have to disregard whatever they claim the law is. Because what they claim the law is not really what the law is. Always stick to the source of a situation to better understand the surface. Many of us, we look at the laws ratified by Congress as being like the law of the land. Many of us don't realize there was a law before that law. And that law, in this sense, was the Second Amendment to the Bill of Rights, which is the supreme law of the land under Article 6 governing the Constitution for the United States of America. That's the supreme law of the land. That is the law that we all are governed by. So when members of Congress, to include state legislators, deviated from that law to create another statutory provision that was in violation of the organic law, that means that the law in which they choose to enforce is criminal. And in order to rectify that, we have to disregard that law in order to uphold the Second Amendment to the Bill of Rights. We have to the Constitution because those in civil service have utterly failed in that endeavor to do so on behalf of us. If they fail to do something, we have to step in and do it ourselves together or as individuals. That is what I've been doing. That is why I have become successful at what I do. That is why I do not fear those in civil service to the extent that many others do. They don't put any fear in my heart. And the only reason why so many people have fear of those in civil service is because so many people are afraid, from what I've been told, of going to jail. But what happens when you take that off the table? How much authority do you really think those in civil service have? Zero. That's what. You all have a good day, though. And it has definitely been an honor, even though not too many people have come into this live stream, for me to speak about matters of public importance to the extent that I have done so here today. And hopefully, at some point in the future, many of you will come back and rewatch this particular live stream in its entirety, even though it went over 1 hour. But there is some good information in this live stream that I have conveyed to you all, in which I believe that you all need to take heed to if you want to see true change occur in this country. Have a good day, y'all. Stay safe out there as well.